and before that, I worked in a similar capacity at Motorola since 2008, and in other roles too since 1999. I'll answer any questions that I can as we go along. I'm not a lawyer. I'm lucky enough to have my coworker Tim Kowalski. So if there's any lawyerly questions, we can pick on him a little bit. So what I'm going to show you today is a distillation of concepts and ideas, some strategies, some thoughts, some ideas that we've used along the way, and I hope you find this interesting. Okay, so real quick with the agenda, we're going to talk about what is a patent. We'll spend a few slides on that. We're going to go into the sticks just a little bit with patentability principles. I think it's important to know kind of the hurdles that need to be cleared in order for you to gain access to a patent. We'll talk a little bit about how patents are used. We'll talk about some of the defensive options with patents and strategies that you can do. And we'll finish up with license on transfer, which I think is an important option available to startups and actually any company. Okay, so first of all, what is a patent? Well, according to the World Intellectual Property Organization, which is a global entity that handles patent concepts, a patent or patent is a set of exclusive rights granted by a sovereign state to an inventor or an assignee for a limited period of time in exchange for detailed public disclosure of an invention. All right? It's a deal, is what it is. So on one hand, the inventor gives the knowledge of an invention, and on the other hand, they get the government-granted monopoly. And in exchange for that, the government gives the monopoly and gains access to the innovations that are disclosed to the public. That's what it's all about. I'll direct you to the Article 1, Section 8, Clause 8, if you guys are interested in this. This is the script that's in the Constitution. Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Now, the blue and the green kind of go together, so it's kind of an interesting aside. Science, authors, writings kind of tends toward copyright. The useful arts, inventors, and discoveries kind of tend toward the patent side. So back in the 1700s, the founding fathers thought it was important enough to include this in the Constitution to facilitate the transfer of innovations and bring forth ideas to the public. Another interesting aside before I move off of this slide, this is the only place within the Constitution that uses the word right. They thought it was that important that they wanted to call that out. All right, so that's enough of that. Let's spend a few minutes on patentability principles because not everything is eligible for a patent. Okay, so essentially, this is not meant to be a patent class, but there are 3 hurdles that have to be cleared. There's a subject matter hurdle, there's an originality hurdle, and there's a form hurdle. Okay, so subject matter, is it patentable? And there's a part in the code, 35 U.S. Code, Section 101. Is it novel? Is it obvious? So is it something that's new? So there's some codes for that, 102 and 103. And is it properly described? So why are those important? Well, for the subject matter hurdle, it might be easier to talk about things that are not patentable. So abstract ideas, essentially material things without material form or practical application. For example, the concept of renewable energy is not patentable. Now, the solar panels that you use that enable that concept of renewable energy, those are patentable, but the concept in and of itself is not. Principles of nature are not patentable. So a chemical element, for example. Physical phenomena, you can't patent a tornado. Mathematical formulae, so the Pythagorean theorem isn't patentable, but new surveying equipment that you use that utilizes that concept is patentable. And then, of course, scientific principles like the law of gravity are also not patentable. So in that vein, if you think about it, what if gravity was patentable? I mean, what if somebody actually had a patent on gravity, or a patent on carbon, or some other chemical element? The idea would be that this would essentially inhibit innovation. And that's not the idea that the founding fathers had. The idea is that we want to facilitate the sharing of this information. And so if we grant somebody a monopoly on something that's so broad as gravity or carbon or what have you, it's not going to give us the information that we need. It's not going to provide to us the innovations that we're looking for. Now, there are some areas that are somewhat controversial. So software is patentable, but if it produces, but only if it produces something that's concrete and useful. If it's used just for mathematical computation, it's not. And you're going to see all kinds of cases in the news about software patents. I'm sure you've seen them already. Business methods are another one that's currently patentable but controversial. So my favorite one is the one-click checkout. So that could be seen as an abstract idea of shopping, but it's still patentable. I'm sure the Amazon people would be very excited if it wasn't. Methods of treating diseases. DNA is another controversial one. So DNA that is found in nature, or human DNA, is not patentable. But if there's a little something man-made that's kind of attached to a form of DNA, there's argument that is patentable. So subject matter. Yes?
Did you say that methods of treating an illness?
Methods of treating diseases, yes. So we run into situations where a doctor may have a procedure, but if they don't have the patent, are they allowed to use that procedure? And there's a whole world behind that. So there's some controversy behind, is it patentable to go ahead and treat some of those?
Or there are some being granted that fit.
Yeah. Let's talk about originality for a second. So no one had ever put a clock on a toilet seat before. So it's novel, it's original, okay? But given the art that's out there in toilet seat land and clock land, would a person having ordinary skill in the art thought to put these two things together? So is it obvious? Well, prior to 1993, it was not obvious, which is why this patent issued. Now, take note, however, that you need more than just the combination of two items to clear this hurdle. So if you have a pencil and you have an eraser and you put them together, the people that have art or knowledge in this area, knowledge of the art in this area, are going to know that it's kind of obvious to attach an eraser to a pencil. So that doesn't clear the originality hurdle. All right, and then to finish up this part, form. So the invention itself must be adequately described to one that's skilled in the art. They must be able to read the disclosure and practice the claimed invention without undue, what they call undue experimentation. So that's, if you have this great idea, but you don't necessarily describe how it's used, you're not really fulfilling your part of the bargain. So the government will give you your monopoly, but if you're not really giving them the idea, you're a little short on that. So that's the first part of that. The second part is the claims. This is where you stake out your property. This is where your innovation is highlighted. And the name of the game is the claim. Is a quote from Giles Rich in 1990. And it was true then, it was true before then, it's still true today. So when you look at a patent, or when people look at patents, they normally flip to where the claims are, and that's where they're going to focus a lot of time on, although there's a lot of other valuable information. Okay, so real quick, patents protect inventions. The scope of the protection is defined by the claims. It's an exclusionary right. It's not a right to use. So if we go back to the toilet seat example, you might have a toilet seat with a clock, but if you don't have clearance to use the toilet seat part, you may not be able to practice your invention. You may not be able to practice that. You'll need clearance. You can, however, use your invention, your patent, to prevent people from using your invention. So it's an exclusionary right. And like a gallon of milk, it expires. So in this case, or most cases now, it's 20 years from filing. Now, patents are just one of a couple of forms of IP that work together in concert. You probably know about the Coca-Cola recipe, the trade recipe. That's a trade secret. Trademark, so the famous Nike swoosh is a trademark that they use to protect their business. Copyright is another form of IP. So this is the Happy Birthday song you may have read about. It's in the news now. Some people think that copyright is expired. Warner Brothers hopes that it's not because they get a lot of money from that particular song. I should have started out by saying that most of what I'm talking about today is U.S. patent. There's certainly patents in the other parts of the world, and each of those other countries has something quite similar. You have a legislative body that's drafting laws and statutes around patents. You have an organization like the USPTO that reviews applications and determines whether or not it's a rejected patent or it's an accepted one. And then the red building is where the Fed Circuit or the Court of Appeals of the Federal Circuit meet to enforce patent law. So these are pretty similar across the world. And I guess it's important to know at this point, there isn't a global patent. So if you file for a patent in the United States, you're not going to be able to exercise your innovation in, let's say, Europe or Scandinavia or China or somewhere else. You need to file a patent there. And we kind of get to this a little bit here. And now, the United States is a great place to file. Why? Because we have a great legal infrastructure. We've got really good IP laws. They're enforced very well. And we have a fabulous market. So we have a place where we can monetize and we can exercise our patents. So take a look at the areas that are in purple, and I apologize for the quality if you can't see. So Australia, Canada, there's some places in Europe that are really well, that have really good developed legal infrastructure for patents. There's some places maybe in the red that aren't so good for any of a number of different reasons. So bottom line, you need to file for a patent in the country that you're interested in.
Does China actually have a patent ministry of some sort? Like
they do.
They do.
They do, and so there is.
Phone line, like you can actually get someone. Exactly, because it seems to me like.
I'm not going to say it's not challenging, although if you've tried to call any place in the United States, you're probably going to run into similar challenges. But there is an incentive for a country to bring their IP standards up to, let's say, purple standards. So there's foreign investments that would flow into these countries. Brazil knows it, India knows it, and China know it. They all know it because they need that investment. They need that turnover of money. There are some places that don't have that, but there is an incentive to raise that up. Now, some of the countries that don't have as developed, so if you're going to Nepal, going to be a little bit more challenging, but there's an incentive there too for them to participate. And they have worries too. So there's in that case you have larger companies maybe exploiting the smaller countries, much to their discredit. But everybody's aware that if the money is flowing, it's because there is a legal infrastructure to support the investment.
So this shows Google's view.
No, this is not Google's. This is from the International Property Rights Index. Okay. It's a little dated. This is 2013. There's an updated one that's 2014. It's about the same.
So maybe this is an unfair question then, but from your own knowledge, I'm surprised to see France and Ireland aren't purple. Do you happen to know why?
There may be some political upheaval. There may be some concerns that they have with the treatment of IP. I don't know what the specifics are, but it's not unusual to think that there's going to be some changes. Yes.
So there are cases where you purple where you can convert, let's say green or red.
Well, it's going to change. So the United States may not be seen as solid. So as the legislation and as the case law changes, the interpretation of IP and the IP law that may raise or lower. So there's some disagreements between Europe and the United States with how certain laws are. Copyright is one, business methods is another. I think there's some differences between the United States and Europe. Europe says business methods, no problem, go for it. United States, not quite the same, not quite on board with that. Looking at that with a little more scrutiny. And so if you're coming into the United States and you have a business method patent, is it going to afford the same protection legally that it would in Europe? And it's not the same. It won't be the same. And so if you take a look at maybe Brazil, not to pick on Brazil, but they have some political upheavals that may question whether or not their legal infrastructure is going to be strong enough to support patents. So maybe they slip back into a yellow from their green. It's gonna move around depending on what the issues are. And then you could talk about DNA and all of that. You know, all those controversial issues are going to factor into what's going on here. And then the more of them that add up, maybe, you know, Russia's got multiple issues that they've got to overcome in order for them to be stable. Let's say stable.
You mentioned like an international body. I mean, if a patent is issued here or a chip or something like that, I mean, I thought there was like some kind of international trade body that, I mean, it's not enforceable, but is
So we talk
something
about
to-
priority dates, and there are some things where if something is developed or something is filed in a certain country, how does the priority date read in another country? I mean, there are some linkages, but the bottom line is, if you want to practice in another country, you're going to have to file another patent.
Is there anything in the works about?
Probably
along
not.
those lines of,
Probably not in my
or
lifetime.
something like that, or?
It's been talked about, but probably not. Do you have anything?
I'll just add a comment. I think what you might be referring to is the Patent Cooperation Treaty, which is what you suggested, an application. So you can file it in the United States as long as, as your U.S. application, or just immediately following your U.S. application, and then you can take that Patent Cooperation Treaty application, file it in Europe, or file it in individual countries.
Right. I thought it would be like tied to like trade agreements and stuff. I mean, but.
Nope.
Never mind.
Now, ideally, but not just yet. And actually, if you take the contrast between a United States and a Nepal, I mean, there's a lot of differences going on there. So it makes it. I mean, those are some of the challenges that they're working through.
You have like NAFTA. You're showing Mexico and the United States, two different ends of the spectrum, and.
Yeah. Great question. Great question. Okay. Okay, so let's shift gears a little bit. Let's talk about how patents are used. I've only got one slide in this particular section here, but there's a lot on it. So there's probably a multitude of ways to talk about this and how patents are going to be used. I chose to put them on a spectrum. So on one side you have defensive, patents being used defensively. On the other side, offensively. You're using them a little more robustly. So we'll start from the left-hand side defensively. And this is a case where you use patents in reaction to an assertion. So in 2012, Facebook was responding to Yahoo's assertion. Yahoo said, hey, I've got 10 patents here that I think you're infringing. They're being a little bit forceful. Who knows what they were trying to do, whether they were trying to gain some money, or if they were trying to, gain an injunction. But Facebook pulled out some patents and said, hey, wait a minute now. I've got these here that maybe suggest that you're infringing. So maybe instead of having a long and protracted litigation, maybe we can sit down and come to an agreement. And that's exactly what they did. So that's Facebook. If we go up to cross-license, if you take a look at Everlight and Osram, they're very active in the lighting space, LED lighting space. You may be in a situation where you know that you're going to be going into an area where there's a competitor that has assets. It may be valuable for you to reach out to that competitor and say, hey, let's get together. Let's do this quite preemptively. Maybe we can strike a deal where you gain access to my patents, I gain access to your patents, and we can avoid a lot of trouble. And that's exactly what they did. Down here with Pfizer, you can use your patents to keep others at bay and recoup your development expenses. So there's Lilly, there's Bayer, and GlaxoSmithKline. Pfizer was able to use their patents in order to protect that space and recoup their investment. You could sell your patents. So IBM, since 1991, has sold over 15,000 patents. And that's fine. You could do that. That's good. There's I think, in fact, the IBM patent department might be funded by their marketing department. So that's something that drives business for their company. You can license your patents. So Nokia, at least since 2013, has generated 500 million euros. So figure $500 million a year just by licensing their patents. Now, when we get to these last two here, maybe the offensiveness might be a little more obvious. So you can litigate for monetary damages. So in 2014, Medtronic agreed to pay Edwards Lifesciences for heart valve patents to the tune of a one-time payment of $750 million and then $40 million a year for another 7 years. So Edward Life Sciences comes up with a nice, $1 billion monetary gain.
Question.
Yes.
In that particular instance, Medtronic didn't know Edward License has that technology before they infringed it, or they just figured to make money regardless.
Well, it's kind of hard to say. I won't suggest that Medtronic actually knew that Edward Life Sciences had assets. You get into an area where you're talking about willfulness, and that adds a whole new layer of, all right, well, is it 750 million or is it 3 times 750 million, depending on whether the court sees it as being a willful infringement or not. So, yeah, I mean, this could be very close to Everlight and Osram on the other side, where if Medtronic knew this, and you don't necessarily have to have knowledge in order to be infringing. So a patent owner may come upon you. You may have no idea that you're infringing. They can still assert, whether you know it or not. The last one here is Brocade versus A10 Networks, and this is an example of litigation for an injunction. And if we go back to what was seen in the Article 1, Section 8, Clause 8 text, injunctions can be kind of tricky because the idea is that we want these innovations to get into the hands of the public. And by issuing an injunction and stopping the shipment of a competitor's product, that kind of doesn't make the courts feel too good about that. They would like to make sure. I mean, there's other remedies. You can certainly sue for monetary damages. But in this case, the court saw that had A10 networks continued to ship their product, Brocade would be irreparably damaged. They would not be able to continue with their business, and so they saw fit to issue the injunction. So that's the spectrum of how patents are used. All right, so what are some ways to protect yourself? Now, before we continue, I'll mention a few things. Patent asserters, non-practicing entities, trolls. These are entities that don't necessarily practice their patents. Maybe they're just using their patents to monetize them. In my presentation, they're all the same. I'm treating them all the same. Non-practicing entity, patent assertion entity, and patent troll, they're all the same. And we can talk about privateering to a certain degree as well, where there's an entity that will get involved with another party to help monetize their patents, but we won't go too far into that. Okay, iChart, and I apologize, but these are a few patent risk management options that I'll walk through real quick. The first one on the far left is Allied Security Trust. Now this is a group of companies pooling their resources together to take patents off the market before they're asserted. So the idea is that if there's a company or a subset of companies within AST that are interested in, they'll chip in, they'll purchase the patent, and then they'll practice what's called catch and release. Purchase the patent, license it to those that had contributed to that purchase, and then release it back out, sell it back out. The next one is Rational Patent Exchange. You may know it as RPX. RPX offers a myriad of services, one of which is dealing with pending litigations, which can be tricky. For the most part, they hold what they buy off the market, so they're catch and hold. And the reason why that they can be engaged with complicated or challenging situations is because there's 220 different companies that are involved. They've got scale. So it's not 20 or 30 companies, it's a big number, it's 220. Now, unified patents is a little bit different because smaller entities can make easier targets. Unified patents looks for these smaller companies to provide kind of a heads up. Hey, Unified, we're being asserted, we small company are being asserted against in these particular areas. That kind of motivates Unified to go and develop maybe an infringement or an invalidity position. So they can begin working on that with the heads up from the startups. The startups in that case join for free, and they focus their efforts in a couple of different areas. Right now it's cloud, content delivery, electronic payments, wireless, and automotive, 5 different areas that they focus on. So, so unified patents. The last one that I have is Open Invention Network, or OIN. Now this is focused on a narrow space. This is in the Linux related area. And the idea here is that patents are acquired and licensed to those that promise not to assert their patents against the Linux community. There's 1,600 plus companies involved with this. So it seems pretty easy. If you want license to the assets that they have, you just promise that, hey, I'm not going to assert my patents against anything in the anybody in the Linux community. Okay, now there's some other initiatives that are explored. These are what I call out-of-the-box initiatives. The patent purchase promotion is one that it just wrapped up a little bit ago. The idea here is to disarm NPEs by providing a venue whereby patent owners can sell, but not necessarily be forced to sell to a non-practicing entity. So they sell a patent to Google, they retain a license to that patent, and essentially remove the likelihood that an NPE will gain access and assert that asset. We launched it this year, but we've since closed it. I'll talk a little bit more about other things coming up in just a second. Patent Starter Program is another one that we started this year that's also closed. The idea here is that a startup would gain access, or would actually gain access to some patents in exchange for joining or participating in the License on Transfer program. The next one, Open Patent Non-Assertion Pledge. This one's a little bit different because it's a promise. It's a promise that we made. I said in certain areas we're only going to use these patents for defensive purposes. Should the patent get sold, that promise stays with the patent. So it's green dotted. We call it green dot. So the idea is that you bind that pledge to the patent, and you have to worry less about what's getting into the hands of a patent asserter. That's still open, 2013. The last one is called License on Transfer, and that's going to be my next section, but I'll mention it here just to keep some continuity. The idea is that you obtain a license effective on the transfer of a patent. We'll talk about that a little bit more. Right now it's open. There are 21 members since its launch last year. So the point with this slide is that there's room for all kinds of creative solutions. And I would hope that, we'll have more, and I would hope that you're going to see some others from other entities as you scan the landscape. All right, so let's talk about LOT, License on Transfer. this is the motivation, really. Back in 2006, most of the litigations, patent-related litigations, were driven by ownership, operating entities. So a fraction were from patent assertion entities. Today, as we project, that number is flipped a little bit. So today, the 68% are driven by patent assertion entities. You see a dip in 2014, but I say that's an anomaly. There's been some legislation that's come through. There's been some changes in the marketplace that I think caused the world to pause a little bit, because the ratio is actually not too dissimilar from what we see here. It's 63 to 37. We've bumped up to 68 now. So I think this also, I think that's just the total number, but the trend is the same. The litigation is coming from the patent assertion entities. And perhaps the most interesting fact is that over 70% of the patents that are asserted come from operating companies. So that seems a little strange. But if you think about companies that are defunct, companies that are distressed, that are looking for funding, and they see, hey, I've got a pile of patents, I'm interested in gaining some money that way. Maybe there's a changed business model. Maybe there's something inherent that changed, or some reason that they changed. Don't let that dip fool you. The trend is pretty clear. So, huge number of troll suits. Had we started license on transfer some 10 years ago, we'd be looking at a different story. We're hoping to make a difference. Yes.
Question, are those US court figures?
Yes. Okay, so that essentially translates into bad economics. The transaction costs are high, and I got to believe that a patent owner is going to think, hey, if I sell my asset to a patent troll, if I make a deal with a patent troll, I'm going to get a return on that. But the numbers don't suggest that. Patent assertion entities pay only 25 up, let's say less than 25%, and in some cases less than 10% of what they earn in a litigation back to the patent owner. So the money isn't really, the value isn't going back to the patent owner, it's going to the patent assertion entity. The cost of patent litigation is enormous. It's millions of dollars just to walk into the courtroom even before you say hi to the judge. Whereas the cost of a patent, if you were to buy a patent on the open market, $250,000 or less. $250,000 might be a little high even. Millions of dollars just to walk into the courtroom. And finally, small companies are heavily affected. Greater than 50% of the PAE suits target companies that have less than $10 million revenue. It's easier to go after, easier prey, and in some cases they'll do that to gain access to the patents that they have in order to bolster their next campaign. So what's the solution? Well, the solution is that lot members agree in advance to grant all members of the lot a license to the patents that they later sell. How does that work? Well, let's say you have two companies that have patent portfolios. Let's just say. Okay, now company 2 sells a patent to company 3. Company 3 is not in lot. Well, at that exact moment, or actually prior to that moment, prior to the transfer, company 1 gains a license to the patent that had just transferred to 3. So now company 1 and any other company within lot gains a license to the patent that was just jettisoned or sold from the lot network. And it's clear, it must be clear that you don't gain a license really until the asset is transferred. So at a high level, the membership, any company, it doesn't have to be just a startup, it could be a big company. Any company can be a lot member. It encompasses the whole entity, parent, child, affiliates, and so on. No confidentiality obligations. The value-preserving provisions are interesting as well. So there are certain areas where certain exceptions where a license isn't triggered. So if there's a legitimate defined merger and acquisition transaction, that may not that merger or acquisition. I'm sure I could have said that easier, but hopefully that came through. Sale within lot does not trigger a license. So if company 1 actually bought the patent from company 2, it's still maintained, the license is still there. And there are certainly defensive suspension terms. So if there is a suit, if there is something, the company that has that patent is able to protect themselves. They're able to protect themselves, defensive suspension. And then, of course, you can withdraw at any time.
Is the membership free?
Membership is not free. It's not free. It depends on the size of the company.
Now, what would trigger a company to withdraw from the lot?
Maybe there's a change in strategy. Maybe there's something that maybe they were sold into something else. They may elect not to be a lot member any longer.
Because it seems to be there's more advantages.
That's what we're hoping. That's what we're hoping with this solution. Yes, absolutely. If you decide to turn yourself into a troll, of course you would leave lot. The hope would be that's not what you would want to do. Okay, so it was publicly launched in last year, almost a year ago. There are 21 companies right now that hold over 325,000 patents worldwide, 99,000 patents in the U.S. So it's a tremendous portfolio just by itself. It's geographically and technologically diverse. So the likelihood is that there's somebody in lot that's going to have something that you would benefit from. And then there's an eye chart here listing the companies. Again, sorry, was there a question? No. A lot of appealing advantages. So it addresses the PAE problem. The idea here is that there are less patents available to be asserted. So there should be less suits. There should be less of a threat. Increases freedom to operate. So essentially a company is going to have a bevy of patents to be free of worry from, for the most part. And they're going to be able to explore, they're going to be able to engineer and innovate without the fear of somebody asserting against them, just looking for a payout. The networking effect is probably understated. The more companies that join this, the more patents that are involved. The more patents that are involved, the more coverage that the different companies enjoy. And there's protection on both sides, whether you're a small company or a big company. For a small company, if you have lots of big companies, like you have today, the likelihood that those companies would spin out a patent and create a patent assertion entity issue for you is very high. It's very high. For the big companies, there's benefit too, because for each little niche area, for each small company, there may be a pocket of really valuable patents that would create some problems for the big companies too. So it works for both big and small. Strengthens the defensive value of the portfolio. I think I just mentioned this. So for a smaller company, it's a handful of patents, or maybe maybe more, to gain access to 325,000 patents. And then there's no interference with the valuable uses of the IP. If the IP doesn't transfer, the patent doesn't transfer, you still have the patent to use however you want to. If you need to assert, you can assert. If you need to protect yourself, you can. You still own that patent. It's still there. It maintains its value. So that's lot. Now, we got a couple more things just in closing. We've gone through the 5 bullets. All of this is meant to provide freedom of action. Why? Because the true magic in any company happens at the engineering level, not in the courtroom. And so that's the idea with all of these concepts and all of these ideas. And freedom of action enables this, and the treatment of the patents is a big part of that. So how do we do it? Well, let's see. Well, we create a defensive position that deters litigation. We have a decent and robust patent portfolio. As far as litigation is concerned, we fight that very aggressively. In many cases, it's actually cheaper and faster to settle, but that may set the wrong precedent. You pay now, you may end up paying again and again and again, as opposed to defending a position. We help patent offices find prior art. So there are tools that we have. There's the Google Patent tool, and there's the Prior Art Finder. These are tools that we've developed. A stronger patent is going to be a better patent. It's going to be less likely to be misunderstood and asserted in a precarious way. We enter into licensing agreements. So the cross-licensing, we have lots of activities around licensing. And then much like Lot, we engage in new initiatives. And there are others, and I would suspect that there are other companies that do the same thing. And then finally, we try to lobby for better patent rules. A stronger system is going to be less likely to be abused. So that is it. That's what I have. If there's any questions, I'm happy to take questions. I got a couple websites for you guys to check out if you'd like.
So for smaller startups that have limited resources, I mean, how much money should be invested in something like this, like establishing a patent, especially when, you know, as an early stage company where you're looking for product market fit, you don't necessarily know where you're going to be. And a lot of us are software companies as well, so that adds another level to the trickiness. I mean, it just seems like companies at this stage, it's not a worthwhile use of the resources to be focusing on something like this.
Yeah, I won't give you any advice. I'll offer this up in that I would explore the different options that are available. I would have a look at some of the things that I had listed. That's definitely one thing. The other thing you'll want to consider is it depends on what your business model is and what you project you think you're going to be. If you think that your market isn't substantial, then you may not need to protect something that's maybe a little bit smaller. If you think it is going to grow into something else, you may need to look at how you're going to protect that. Yes.
If you're a foreign company coming into the U.S., I mean, where would you direct it? I mean, to say, look, you have, whether it's software or some sort of device that needs to have patent protection or should have patent protection.
It's going to be a similar answer there. It's going to depend on what your segment is, who your competitors are, what the turnover is.
Is there like, an entity? Where do you go? I mean, you find an IP lawyer and say, here I am, and I need to know what I need to protect. I mean,
an IP lawyer probably help you write that patent. There should be an awareness of what that market is, and there are different places where you can get data. I could think of a number of sources that might provide the one that's coming to my mind is like a Gartner hype chart that says, look, here we are today. This is budding technology. We can see that there's a path to a robust market within the next 3 to 5 years. Here's another part on that graph that says, hey, this is a technology that's maybe worn itself out. It's matured. Unless there's some new innovation in this space, we can see this kind of the long tail at the end there kind of fading out. We can see that. That'll go into that should feed into your decision as to whether or not you need, or how much you need to protect, and where it is that you need to focus your efforts on. It'll also depend on who else is in your area, who else is innovating in your area. There's a big difference between, let's say, a handful of startups, let's say 15 or 20 startups working in an area versus a handful of startups and you've got a big dog like an IBM or a Google or some other substantial company that's investing efforts there. you need to watch that. Are there any other questions?
Just one last one about like, in the chip space, you see a lot of workarounds.
Yes. That's perfectly fine. In fact, that's what the disclosure of the patent does. It provides other companies to build it off of those innovations. It also gives the chance for companies that may not, it gives a chance for companies to work around that innovation. And the really good patents are ones where, hey, look, this you can't work around that. That's rock solid, and there's no working around that. You're going to have to talk to whoever the toilet seat holder, the patent of the toilet seat. He's rock solid. You're not going to work around that one.
Question.
Yes, sir.
When in the startup stage, would you say a company should seriously consider being part of this network?
I would say right away. You want to consider your pet.
Well, it could be that your idea isn't flashed out, you kind of, you're still incubating the idea, and then when you get to know that, look, this is solid, I can monetize this, but when you start joining or from the very get-go, that's what you're saying.
Well, so again, we'll go back to unified patents where they're looking at startups. So they're saying, look, where is this area? Is that actually going to grow? Are there alternatives in the marketplace that are going to compete with that? If there is serious competition from other alternatives, maybe that's going to be a little bit more difficult to work itself through. But if it is truly pioneering effort, you're going to want to write some things down. You're going to want to get that secured. It's a big world, and information moves really fast these days.
If I can add, Eric, I think there's two aspects to your question, at least how I interpret it. I mean, one is the patent procurement, and when your idea is baked enough that you think you kind of figured out how it's going to work, it's probably the time to talk to a patent attorney or you as an expert in the area. You probably have a sense as to whether this is new from a technology standpoint and whether there's something you can move forward with, and you can have that dialogue with the patent attorney. On these defensive options that Eric spoke about in the second half of this presentation, those are to mitigate for patent infringement liability, and patent infringement liability arises when you're making, using, selling, importing products that infringe a patent. And so if you're in the stage of your companies in the early stages where you're not essentially doing any of those activities, you're not making product, you're not offering services that infringe a patent, well then you have to look at each specific case, but it's likely that you're not liable for any patent infringement, and therefore you can still join these organizations, but the real bang for the buck comes when you're out there offering something that can create or doing something that can create infringement liability.
Thank you very much.
Thank you.